Prior to the motion to strike being heard, counsel, do either of you have anything preliminary for us? All right, each of you have 5 minutes. Ms. Larondo, I understand you're taking 3 and then 2.
Yes, Your Honor.
You may proceed.
Mr. Chief Justice, may it please the Court. The Court should strike the challenge statements from the declaration submitted by petitioners for 2 fundamental reasons. 1, the declarants don't have personal knowledge of the future impacts of the challenge laws on all Idaho women and all Idaho healthcare professionals. 2, petitioners attempt to extrapolate from their limited personal knowledge to offer lay opinion testimony is the statement of the proverbial expert in lay witness clothing and is impermissible. With regard to the lack of personal knowledge required by ER 602, petitioners have failed to lay any foundation that their declarants have knowledge of the circumstances and opinions of all Idaho women and all Idaho healthcare providers. At most, petitioners have some degree of knowledge about the facts of the treatment of the women they have treated and about the women who come to certain Planned Parenthood centers. They don't have knowledge about anything beyond this, including what might happen in the future in response to the challenge laws.
Counsel, I understand you to be saying they have some knowledge, but not all knowledge. Wouldn't that go more to the weight than the admissibility?
Your Honor, I disagree. And that is because the petitioners are limited to testifying by ER 602 to what's in their personal knowledge, and then they can offer opinion testimony that kind of extrapolates from that personal knowledge. But as I will discuss in a minute, and can discuss now, they cannot offer lay opinion testimony to these matters. And so the proper thing for this court to do would be to strike the challenge statements rather than to weigh the weight of the challenge statements. To go to their attempt.
So counsel, I'm somewhat confused in that it seems like the testimony that is proffered by the petitioners suggests that the legislation is operating in the way that it was intended to operate. And you seem to want to tell us that the testimony that says the legislation is operating in the way that it was intended is not what we should be listening to or looking for.
Well, Your Honor, I am merely concerned with the fact that what petitioners have done is not evidentiarily proper. And in this original action, the rules of evidence still do apply. And so to the extent that the court is going to be weighing petitioners' declarations, they need to be evidentiarily admissible. And they just simply are not. With regard to petitioners' attempts to extrapolate from their limited opinions into lay opinion testimony into ER 701, this court's September 2nd decision in State v. Smith makes clear that petitioners' efforts are impermissible lay witness testimony. Because there, this court held that a nurse who applied her specialized knowledge to determine that a dark discoloration on dark skin was a bruise as opposed to something else was impermissible lay opinion testimony. And that's exactly what happens here when petitioners take the very specific facts that they know and try to extrapolate that knowledge to apply Idaho-wide.
But the problem in Smith was that the expert testimony had not been disclosed as expert testimony.
That is correct, Your Honor, but the underlying rationale for why the court concluded that the expert witness testimony was not disclosed properly was because the testimony that was proffered was actually expert testimony as opposed to lay opinion testimony.
But it was because it hadn't been disclosed, not because there's some fundamental distinction between lay and expert witness testimony.
Your Honor, I disagree. I think that under the court's rationale, the fact that it was expert testimony was the predicate for the court concluding for it had to be disclosed as expert testimony. So for, petitioners admit this, that they're offering lay opinion testimony by their citations to supporting studies and by Planned Parenthood's use of expert testimony to establish these very facts in related district court litigation, where they offered the testimony of sociologists and economists. For these reasons, the state respondents respectfully ask that this court grant their motion to strike in all 3 dockets. Thank you.
Thank you. Sir.
Morning, Your Honor. May it please the court. I'm happy to address why the declarations are consistent with Rules 602 and 701, but first I think it's worth pointing out that all of the state's arguments are inconsistent with this court's original jurisdiction precedent. In Reclaim Idaho, this court emphasized, quote, that it's essential for the court to have access to all the relevant facts. The objections here, as Justice Mueller pointed out, all go to weight and not to admissibility. And this court is obviously well situated to assess the proper weight to be given. Here, as in Reclaim Idaho, all of the witnesses have, quote, considerable personal knowledge and experience with what was there, the initiative and referendum processes in Idaho, but here, the provision of health care and specifically the provision of abortion care in Idaho. Similarly, in writ of prohibition, this court recently said that, quote, considering the gravity of the constitutional claims implicated in the petition was outweighed, or those interests outweighed, or were outweighed by any interest in addressing the merits. Similarly, in Reagan, this court forgave a number of procedural deficiencies in the petition and also relaxed the standing requirements in the interest of addressing the significant constitutional issues presented there. I'll get to the point that all of these comply with Rule 602 and 701, but I think it's worth reminding the court of the backdrop here for original jurisdiction cases. This court has repeatedly said, including in Van Valkenburg, that the standard is whether the petition, quote, alleges sufficient facts concerning a possible constitutional violation of an urgent nature. And in original petition cases like Van Valkenburg, the court hasn't hesitated to resolve claims just like these without the benefit of admissible evidence. In Van Valkenburg, for example, the court had no difficulty concluding that the pledge legends would, quote, potentially mislead voters. It's also worth considering the implication of the state's position here, which is that pre-enforcement challenges to unconstitutional laws are all but impossible. I mean, in order to show an irreparable harm in a case like this one, or in a case for preliminary injunction, a witness clearly needs to make some predictive judgment as to the impact that the challenge statute will have on the affected parties, and that requires using the factual basis for the declarant's knowledge to make rational, reasonable guesses or expectations about what the statute is
Counsel,
going
where
to
is the
be.
foundation for those kind of guesses? You're right, this is an original action. Let's say we were having a trial today instead of an appellate argument, and we had a witness come on the witness stand and say, well, this is how all women in Idaho feel. If the state objected to that, I suspect we'd probably sustain that objection as being overly speculative.
That may be right, but I don't think there's any testimony in the declarations that come anything close to saying this is how all women in Idaho feel. I mean, for Dr. Gustafson, for example, she establishes that she's a practicing family medicine doctor in Idaho for nearly 2 decades. She draws rational inferences about whether, why, and when women seek abortions based on her decades of providing this type of care in Idaho. She establishes her personal understanding of the statute and its impact on her practice. And as Justice Stegner pointed out, the impact of the statute here isn't something that requires an expert to weigh in. It is a total ban on the provision of abortion in the state. And the effect of it would be to ban abortion in the state. With respect to the 2 affirmative defenses available under the total abortion ban, Dr. Gustafson says that she will not be able to provide abortion care consistent with her, medical ethics as an abortion provider because they are unclear. She further states, based on her expectations, based on decades of personal experience, about the impact of the ban on women seeking abortion. I think all of that is a rational inference, which this court said in Dacey is precisely what a lay opinion witness is entitled to give based on the bona fides that she establishes as a medical provider in Idaho over 2 decades. I think the same is true of Christine Smith. She spent a decade working for Planned Parenthood, 8 years as an area service director in Idaho. She establishes that she's familiar with the operations, services, and communities served by Planned Parenthood in Idaho. She establishes that she manages the Idaho clinics. She introduces data from government sources and scientific literature familiar to people in the field. And she draws.
So just a second, on her citations to that evidence, it strikes me that's hearsay. Why does she get to testify to that?
So I think there's a number of different sources, but at least with respect to the government sources, which is principally what she relies on, I don't think there's any. I think there's an exception to the hearsay exception for government sources or information that's publicly available, which even the court could take judicial notice of. She's reading relevant statistics into the record to establish the context for the availability of abortion care currently in Idaho, and I don't think there's any viable hearsay objection to that evidence coming into the record through a knowledgeable declarant.
Well, I think you may get to directly introduce that, attach it to your declaration, and argue the hearsay objection, but I don't know that you get to take a lay witness and have them selectively paraphrase parts of it and read it into the record.
I don't think the state's objection is that the recitation is partial, and in any event, the statistics are there for the court to see. I think their objection is that Ms. Smith doesn't have the personal basis to talk about the specific context of abortion care in the state of Idaho, and citation to CDC records to establish the percentage of women in Idaho living in poverty and their access to abortion care, I think is well within her personal knowledge or rational inferences that can be drawn from government data for people who are knowledgeable in the field.
Well, I think the objection, as I read it, is that while she says, I do these big overarching tasks I manage and I'm familiar with, we don't have any context for what that means. Because in different contexts, managing a clinic can mean different things, particularly when she manages clinics in a variety of states.
I certainly understand that. She also specifies that she's knowledgeable about the communities that are served in Idaho, and I think she goes on at length in her declaration to establish the bona fides of that knowledge. She's been working in this community for 8 years, is knowledgeable about the population that's served, and is knowledgeable about the impact of the availability of abortion care and the withdrawal of that abortion care on these communities.
Is the evidence in the two affidavits relevant for anything other than standing?
So I think it certainly goes to this court's original jurisdiction. Because it establishes a constitutional violation of an urgent nature necessitating this court's intervention. It certainly goes to standing. I do think there are aspects of the declarations that go to establish or illustrate the profound impact of withdrawing abortion care on patients in Idaho. And for that, I think it's relevant to the establishment of the constitutional right and the gravity of the constitutional right, and also the imposition of the burden on women in Idaho from the withdrawal of abortion care. So I think it's relevant in all those respects. I don't think it's outcome determinative in any of those respects. And I think for the reasons that I gave based on the court's other original jurisdiction precedent, the court's well within its right and has ample recourse to the record here that would allow it to adjudicate all of these issues.
Well, sir, thank you. Madam Clerk, how much time does the movement have remaining? Counsel?
Thank you, Your Honor. I think that this court has thoroughly discussed the fact that the rules of evidence do apply in original jurisdiction matters. And I'd like to discuss the Reclaim Idaho matter that my friend discussed. There, the court did apply the rules of evidence and strike certain challenged lay witness testimony. And with regard to the expert witness testimony that my friend is referring to, those were individuals who may not have been a doctor so-and-so, but they were allowed to give the testimony they did about the impact of the initiative law changes on Idaho initiative gatherers because of their particular expertise. Now, in contrast, what my friend is saying is that his declarants can testify to, this is how all Idaho women feel about the abortion laws. And by extension, saying this is how all Idaho doctors will react to the abortion laws. And you simply cannot have one person's limited experience inform what will happen Idaho-wide and how everybody in Idaho will feel. But I want to emphasize the fact that petitioners in their discussion today do concede that they're—
Counsel, I believe your time's up.
Thank you.
Thank you. With that, sir, you may proceed.
Thanks very much, Your Honor. For 50 years, generations of Idaho women have had control over their bodies and lives with respect to the most intimate, personal, and private decision imaginable, whether to carry a pregnancy to term or whether to terminate it. The Idaho legislature now seeks to upend women's lives and strip them of their most fundamental right, one that's necessary to the exercise of numerous other rights that all Idahoans cherish. The Idaho Constitution forbids that result. Numerous provisions of the Constitution, standing alone and taken together, protect a woman's right to bodily integrity and autonomous decision-making related to procreation, including the right whether to terminate a pregnancy. Recognizing that there's a right to decide whether to terminate a pregnancy respected by the Idaho Constitution is the starting point of the analysis. It's not the end of the matter. It means that when a state attempts to regulate or ban certain abortions, Idaho courts will be required to evaluate the state's interest in the particular statute against the woman's own respected interest in deciding whether to terminate her pregnancy. The alternative is rational basis review, which doesn't accord due respect and weight to both sides. I know we have 3 cases before the court, but if it's okay with the court, I'll start with the total ban. Obviously happy to address any of the court's questions on any of the issues here. The Idaho Constitution protects the fundamental right to procreation. Even before Roe, this court recognized a fundamental right to procreate in Stuckey in 1972. It has continually and repeatedly since that time held that right out as the most obvious fundamental right alongside voting. An obvious incident to the right is the decision whether to procreate, as numerous state courts have recognized.
Why is that obvious? It would seem to me that procreation would be the opposite of abortion.
So I think procreation is the right to make choices about whether to procreate or not. I mean, the decision about whether to have your body become a vessel for the birth of a child, I think, is the decision that's protected by the right to procreate. And for reasons that this court has recognized under Article 1, Section 1 and Article 1, Section 21, the decision whether to procreate, the decision whether to bear a child or not, and the decision about whether to submit one's body to the 40 weeks of toil entailed in pregnancy, I think is respected by the Constitution and entailed in the right to decide whether to procreate. Article 1, Section 1 protects inalienable rights, including the right to, quote, life and liberty, and also to, quote, pursue happiness and secure safety. And Article 1, Section 21 underscores the heightened protection that's accorded to fundamental rights. Few other decisions so gravely implicate these constitutional promises. And this court has recognized a right to privacy in Murphy, Murphy versus Pocatello. And I think the language of that case is pretty important here. The court said, quote, the absence of a specific constitutional provision dealing with the rights of privacy, personal taste, the right to be left alone, and the like, does not compel the conclusion that no such right exists. On the contrary, the opposite conclusion is compelled. The court said that in the context of the Ninth Amendment and immediately turned around and said that that particular right is protected by Article 1, Section 1 and Article Section 21 of the Idaho Constitution. Similarly, this court has repeatedly recognized a, quote, right to self-determination and bodily autonomy in Peckham and in Greenhow. Pregnancy profoundly affects a woman's physical and mental health in the entire course of her life. Even uncomplicated pregnancies challenge a woman's physiology. Higher heart rate, increased clotting, breathing changes, digestive complications. They can aggravate pre-existing health conditions, including hypertension, cardiac disease, diabetes, kidney disease, autoimmune disorders. Labor and childbirth are fraught with risk of mortality and other complications. They're much riskier than abortion. It also has a substantial impact on women's autonomy, life course, and well-being. And it has a substantial impact on a pregnant woman's other children. For all these reasons, and based on similar constitutional traditions, based on similar constitutional language, adopted around the same time, reflecting the same constitutional philosophy, and against the backdrop of a long history of criminalizing abortion, state high courts, including of Minnesota, Kansas, Washington, Montana, and Tennessee, have all recognized that the right to an abortion is protected under the Constitution. And there are currently injunctions in Utah, Wyoming, Ohio, Indiana, and Michigan, recognizing the same right protected under those state constitutions. Those aren't from state high courts, but they nonetheless interpret state constitutions to protect the right to an abortion, and they're indicative of how those state high courts will decide the issue once it's presented to those courts on appeal. Beyond Article 1, Section 1, and beyond Article 1, Section 21, there's Article 1, Section 17, which this court has repeatedly recognized reflects a broader protection for personal privacy than the federal Constitution. Courts confirmed that in cases like Donato and Thompson and others. And importantly, that broader protection than the federal Constitution allows isn't limited to cases involving physical premises, nor is it limited to cases where the rural nature of the state indicates some broader protection. For example, in the case about a broader concept of curtilage based on Idaho's unique rural nature. Thompson simply disagreed with this.
Sorry, I don't understand that. Why? What is it about a rural versus urban area that would change the analysis?
So my point is only that this court's broader interpretation of Article 1, Section 17 is not limited to circumstances where something about the physical landscape of Idaho suggests a broader interpretation. In Thompson, for example, this court departed from the Supreme Court's interpretation of the Fourth Amendment with respect to pen registers, having nothing to do with unique features of the state, at least landscape-wise. And the court simply said that Idahoans deserve better, that there's more protection from government interference into the, quote, most intimate details of a person's life. In other words, this court has long interpreted the Idaho Constitution to allow, Section 17, to allow more privacy protections than the federal Constitution allows. And while some cases are limited to aspects of Idaho's landscape or tradition that relate to its particular landscape, I keep using the same word, but that's not a limitation that the court has ever imposed. And Thompson is simply about the expectation of privacy enjoyed by Idahoans and protected by Section 17 of the Constitution. Donato also asked about whether there's a, quote, common expectation about protected information in the state. I think it's important here that there's a 50-year history of a protected right in Idaho that strongly favors the non-retrogression of this fundamental interest. Today, there is a common expectation of privacy that respects the choice, the private choice, to decide whether to terminate a pregnancy. There's a long history of criminal statutes in the state of Idaho, pre-Roe, and we talked about this some at the last argument, but it doesn't affect the analysis. Under settled Idaho laws we describe in our briefs, a right is fundamental if it's implicit in the concept of ordered liberty. The test does not look to history or tradition, and that's an important departure from the federal test. What does that mean? It means that a right is fundamental under the Idaho Constitution if it's necessary to preserve and exercise other basic civil and political rights. If it is, to quote Justice Cardozo in Palco, the indispensable condition of nearly every other form of freedom. The history of criminalization of abortion in this state doesn't bear on whether the right to decide whether to terminate a pregnancy is indispensable to women's exercise of every other form of freedom. The Kansas Supreme Court's analysis in NowThis and NowThis is persuasive. There, criminal statutes didn't necessarily reflect the will of the people. That was evidenced by the widespread availability, or it's evidenced here by the widespread availability and use of abortifacients in the state's territorial days and in the early days of statehood. And the state points to one criminal prosecution in 100 years under the criminal abortion statutes. Moreover, the constitutionality of the statutes was never tested under the Idaho Constitution. So there's no conclusive determination as to whether that long history of legislation is consistent with the Idaho Constitution.
So just so I'm clear then, the 130-year history of the Idaho Constitution, are you suggesting that this right was intentionally placed into the Constitution by the founders in Section 1, subsection 117 and 21 of Article 1, that it was put there intentionally, or that it was put there inadvertently, or that it was just kind of latent and hidden and we've just recently discovered it? Or are you suggesting that our jurisprudence has somehow pulled that out and it's grown into it? Or is this just a product of our modern times and society evolving?
So let me answer the question in a couple of different ways. I think the Constitution has been clear since its establishment that what it protects is liberty, equality, the ability to pursue happiness, and the ability to secure safety. And the founders and framers recognized that those were not static, stagnant rights, but instead they would evolve over time. And I think there's no better example than the court's decision in, I think it's Troutman, which is the corollary to Buck v. Bell, where this court recognized that the forcible sterilization of people with mental disabilities or mental illnesses was consistent with the Idaho Constitution. This court would never reach a similar conclusion today under the Idaho Constitution. There's an evolution even though the terms of the Constitution remain the same. Murphy versus Murphy is another great example. In that case, the court considered whether an alimony statute that disfavored fathers and preferred mothers was inconsistent with the promise in Article 1, Section 2. The court recognized that the same legislature, the territorial legislature of 1875, is the legislature that was the legislative backdrop for the adoption of the Constitution in 1890. And the court never at that, or the framers would never have thought at that point that alimony statute, which provides for alimony only to a dependent woman, was inconsistent with a constitutional promise of equality, and yet this court concluded in Murphy that it was unconstitutional.
Then how do we look at a case like our 1901 decision, just 11 years after statehood in State versus Alcorn, in which this court, the Idaho Supreme Court, said that abortion violates decency, the best interests of society, divine law, probably something we wouldn't cite today, or the law of nature, and the criminal statutes of this state? It seemed like there was no ambiguity in the eyes of the Idaho Supreme Court in 1901, at least.
So State versus Alcorn was a criminal prosecution under one of the statutes where the doctor had left the patient bleeding on the chair, fled the state, and came back and was prosecuted under the statute. It is the one criminal abortion prosecution that the state has ever pointed to and that I've been able to locate in all of my research. The fact that there was one prosecution where the court in dicta made observations...
Well, just to be accurate, it's the one prosecution that was appealed.
Certainly, but I think if you look at the case law of other states, we point to cases from Texas, Kentucky, Kansas, there's tons of abortion, of decisions under the state abortion statutes during the same time period. So it does suggest an under-enforcement of the criminal abortion statutes in Idaho's early statehood days.
Do we really have evidence in the record that would allow us to make any sort of conclusion about the enforcement of Idaho's abortionist statutes?
So I think the
early
one
statehood?
relevant, I think there's two relevant data points. The first one is the advertisements that we point to, which show that abortifacients were widely available and openly and notoriously publicized to women in Idaho in particular. And number two, one example of a criminal prosecution in the early days. But again, I think that I was answering Justice Mueller's question directly, and just to put it in context, I don't think that the early enforcement of the criminal abortion statutes is relevant to the question of whether the right is fundamental. This court has purposefully decoupled the inquiry into whether a right is fundamental from history and tradition, and the question is whether it is implicit in Idaho's concept of ordered liberty. I think that's a marked, significant departure. And so history and tradition doesn't dictate whether the right is implicit in Idaho's concept of ordered liberty today.
How persuasive are these ads, assuming they even are covering abortifacients, as you say? I mean, I see ads in newspapers for marijuana. I don't think someone in the future could construe from that marijuana is legal in Idaho.
It's not a question of whether it's legal or not. I think the question is whether it is. The specific point we rely on those advertisements for is to underscore a point made by the Kansas Supreme Court in Hodes and Nauser, which is the early legislation about abortion doesn't necessarily reflect the will of the people, and so shouldn't be given conclusive weight when this court is trying to evaluate whether this is a protected right or one that's implicit in Idaho's concept of ordered liberty. That's the limited purpose for which we're trying to use it here. And I think coupled with the lack of enforcement history, I think it undermines the state's contention that this is that the state's history of criminalization of abortion necessarily forecloses the possibility that it is a fundamental right implied in Idaho's concept of ordered liberty today. And I think for all the reasons that we've been discussing, it is. I mean, it's adjacent.
Well, and counsel, you can have a fundamental right. It doesn't prohibit the state from trying to regulate
Absolutely.
the fundamental right. So as I understand your argument, you're saying there's a fundamental right. The abortion statute doesn't mean that fundamental right didn't exist. It's just the state trying to regulate the right.
So I want to make sure I understand the question. Establishing something as a fundamental right absolutely does not mean that the state can't regulate it. It's subject to strict scrutiny. The state can certainly regulate it. First off, what we're dealing with here is not a regulation, it's a ban. This is an outright ban on abortion under the state, and I think what this court said in Reclaim Idaho is that no matter how noble the legislature's intention, it can't read a right out of the Idaho Constitution, and that's simply what the legislature is trying to do here.
Well, the right in Reclaim Idaho, though, was specifically provided for in the Idaho Constitution. It was a positive right that said the people of the state of Idaho reserve the right to directly legislate.
Absolutely.
How is that comparable to abortion?
I think the court said in Evans that a fundamental right can be established one of two ways, either that it's established as a positive right under the Constitution, or if it's implicit in Idaho's concept of ordered liberty. And I don't think Evans or any of the court's subsequent decisions have suggested that those two ways of establishing a fundamental right are on different footing from each other. They both are different ways of establishing that the right is fundamental, which again simply triggers the application of strict scrutiny. What establishing...
Well, you would agree, though, if the right's in writing, that would be a lot better foundation than if we're looking for it in penumbras or rights to privacy that aren't specifically mentioned in the Constitution.
I think, respectfully, Your Honor, I think Section 21 says exactly the opposite thing, and I think the court's language in Murphy says exactly the opposite thing. What Section 21 says is that rights that are not expressed in the Constitution are reserved to the people. And so there is an entire body of rights not expressed in the Constitution that the Constitution nonetheless recognizes are reserved to the people. Those are fundamental rights anterior to the Constitution of the state that are embraced by the Constitution through the language of Section 21. And so I don't think it makes any difference for purposes, I mean, it makes our task today more difficult, but I don't think that it makes any difference in terms of the stature of the right under Idaho law, whether the right is positively expressed somewhere else in the Constitution or whether it's simply one of the reserved rights enshrined in Section 21.
Where did the Evans Court come up with the ordered liberty test?
So the ordered liberty test, I think, goes back to, the United States Supreme Court has been using that language for some time. And I can't remember the first case that it comes in, but it's in this.
Alco versus Connecticut?
It's possible that that's the articulation. But in Evans, I think the court was citing to Washington versus Glucksberg, the Supreme Court's decision about assisted suicide. And there, the Washington versus Glucksberg decision specifically says that a right is fundamental if it is implicit in the concept of ordered liberty and deeply rooted in the history and tradition of the nation. And that's the formulation the Supreme Court used in Dobbs. This court made a very purposeful decision in Evans to follow, for purposes of the Idaho Constitution, only the implicit or implied in the concept of Idaho's concept of ordered liberty, and to excise the history or tradition language. It was right there in front of the court. The court explains in Evans that it is going through an elaborate, deliberative process about how to articulate the state standard for demonstrating a fundamental right. It goes back to the Supreme Court's decision in Ramirez, and it discusses the majority and dissenting opinions there, and it reaches the conclusion that this is the test that's going to govern. And the court's never retreated from that test since the first Evans case. And so that is
The Supreme Court certainly has, right, under the Benton case?
The United States Supreme Court?
Right, abandoned the ordered liberty test.
I apologize, I'm not familiar with Benton, but certainly in Dobbs, the court rejects the notion that the right to abortion is implicit in the concept of ordered liberty or deeply rooted in the history or tradition of the United States, and that's the Supreme Court's most recent articulation of the right in this particular context. And so I apologize, I'm not familiar with the case, the US Supreme Court case you're talking about, but for this court, I don't think there's any dispute that the Evans standard governs, and the only question is whether the right that's being that's at issue today is one that's implicit in Idaho's concept of ordered liberty. And I think for all the reasons that we've been discussing, we've established as the petitioners that it is. So I think I addressed the long history of criminalization of the statute, and I think I've also addressed, in response to Justice Muller's question, that the argument that history or tradition at the time of the Constitution's enactment is inconsistent with case law establishing that history and tradition are not part of the fundamental rights analysis. And also, it's quite perilous. I mean, according to the founders and their contemporaries, intermarriage was unlawful, selling alcohol or guns to Indians was unlawful, indecent language couldn't be used in front of women, and sterilizing people with mental illness or mental disability was not only good public policy, but fully consistent with the Idaho Constitution. And so locking the liberties and the pursuit of happiness and the right to secure safety in time, freezing it in time as of the 1890 Constitution, I think is a perilous endeavor. And in any event—
Weren't most of those things fixed by the people either amending the Constitution or the legislature enacting laws to prevent those things?
I mean, I don't think there are any relevant amendments to the Constitution that affect any of the ones that I've just talked about. Certainly there's decisional authority from this case. For example, either from this court or the Supreme Court striking down, for example, the ban on intermarriage or interracial marriage. But I think the question, as I understood Your Honor to be framing it earlier, is sort of when did this right become part of the Idaho Constitution? And I have two answers to that. The first is that as of the date of enactment, the Idaho Constitution recognized a right to be left alone, a right to privacy. Those are fundamental rights that I think the Constitution reserved to the people under Section 21. This court has had no difficulty concluding that those are fundamental rights, and I think Murphy is the signal case, certainly on the privacy right, but even the case that I mentioned earlier, Justice Jones' opinion, recognizes the right to bodily integrity and the physical integrity of one's body, and also self-determination. And that's a case about what information a patient is entitled to for implantation of a dental crown. I mean, the issue that we're talking about here is so much more invasive and so much more conscriptive of a woman's body than that. And so to think that it doesn't violate her right to autonomy or self-determination or bodily privacy or integrity, I think diminishes the right almost into non-existence.
Despite this right of bodily integrity that you've just mentioned, I'm struggling to understand exactly what it means. Does it only apply to abortion, or does it apply to other things like employers that want to require a vaccination mandate or mask mandates, or does it apply to things like individuals that want to undergo experimental surgeries that have not been authorized in the state of Idaho? This right to bodily autonomy seems incredibly amorphous to me.
Certainly, and I'm not asking for the court to elaborate on the contours of the right here. I am asking the court to recognize that the right to decide whether to have your body used for the state's purpose of ensuring the life of a fetus for 40 weeks, whether that violates whatever concept of bodily autonomy we're talking about here. Again, I mean, the court has recognized the right to bodily autonomy outside the abortion context, in the context of a case about what information is necessary to get informed consent for implantation of a dental crown. And so it would follow to me that if you're talking about the right to bodily integrity and self-determination in that context, a woman's ability to decide whether to be forced to carry a child to term perforce is a violation of that right to bodily integrity. I think with respect to the other examples that you've given, they're incredibly interesting. I think none of them involves the degree of control exercised over a woman's body for 40 weeks in an incredibly dangerous, set of circumstances in particular cases. And to take the last example you gave about about deciding whether to engage in experimental treatment for a particular medical condition, there, presumably, the patient has the choice. I mean, that's what we're talking about here, whether the patient has the choice to undergo that procedure because they're given the full respect and dignity to be able to make the decision about what is best for them under those circumstances. And the point here is that a woman is being stripped of that dignity, and a woman is being stripped of that autonomy and respect, and she's being stripped of the ability to control the fate of her body.
So does that right to control, does it extend the entire 40 weeks?
So I think that the right does extend over the 40 weeks. The question then is, what is the competing interest that the state asserts, and whether it meets strict scrutiny. And so, there's plenty of litigation and there's plenty of decisional authority that had to balance those interests under both strict scrutiny and the undue burden standard, which applies to regulations rather than outright bans. But there's plenty of case law that would assist courts in deciding whether a particular durational ban or a particular other type of regulation of abortions constitutes an unconstitutional infringement of that right. And I'll concede that the state's interest becomes greater as the viability of the fetus becomes more promising. But a total abortion ban that allows the state to forbid the termination of a pregnancy from the moment of conception, I think, reads the right entirely out of existence and gives no respect to the woman's fundamental right to bodily autonomy and dignity.
What about a law that's not a complete ban, like the 6-week ban that's at issue here?
So I think that similarly fails under strict scrutiny. I don't think the state has any interest in prohibiting an abortion that early. I think we explained the reasons that it fails strict scrutiny in our brief. I think the normal standard, at least in the pre-Dobbs era, was that at least through viability, there was a presumption that the ban was outright unconstitutional because it infringed the protected right to such a degree that no asserted state interest could defeat that.
So just to be clear, then the problem with the 6-week ban is the 6 weeks?
From a strict scrutiny, from a sort of balancing standpoint, yes. We have other problems with it.
I just wonder where this leaves us. The Supreme Court in Casey recognized that Roe was on a collision course with itself, and that as science improves and as viability becomes earlier and earlier in a pregnancy, we're going to have the exact problems that we're having here today. You began your brief, I thought, on a hopeful note by noting that there are some times that you concede when the state may have a compelling interest. How do we define that?
So I don't think that these are the cases to define it. I think it is one of the things that benefits from judicial decision-making in the context of specific legislation. But what the state has attempted to do here, we're not here on the 20-week ban. We're not here even on a 15-week ban. We're not here on an ambulatory care requirement. What we're here on is a total abortion ban and a 6-week ban that are terribly written for reasons that we can get to in a moment, but that ban the procedure outright with 2 affirmative defenses on the total abortion ban that are affirmative defenses and also are completely unusable from the vantage point of the provider. And then a 6-week ban that does have exceptions, but for other reasons is, impermissibly vague. But I will say, just to make the simple declaration, recognizing that abortion is a fundamental right does preclude a total ban and a 6-week ban. Where exactly the line should be drawn later in the pregnancy, I think that viability is at least a good starting point. But certainly a total ban and a 6-week ban go well beyond the state's interest in protecting fetal life.
Why?
Sorry?
Why?
There's no chance.
So let me give you a little context. So the state is arguing our interest is no less compelling at the onset of a pregnancy than at 6 weeks, 12 weeks, 15 weeks, 20 weeks. So help me understand, you're talking about balancing. As a judge, I have to interpret and apply the law. And I've got a strict, if we find a fundamental right, I've got a strict scrutiny test that does not talk about balancing at all. It says, is there a compelling state interest? Is this necessary and narrowly tailored to further that compelling state interest? So I'm not clear where balancing comes in, and do you have a case you can cite me to stand for the premise that if the state does have a compelling state interest and it is narrowly tailored, that it can't completely ban or override that right?
So I agree with you that balancing is not the right terminology, and you've obviously stated the strict scrutiny test correctly. I think the best case I can point you to is Reclaim Idaho, where the court, I don't think, disputed that the legislature had a compelling interest in what it purported to be doing, but the court was quite clear that a compelling interest can never allow for reading another fundamental right out of the state constitution. And so a total ban doesn't do any balancing. The state's compelling interest in preserving preborn life has to give way to some type of accommodation for the woman's interest in making the decision whether to terminate pregnancy. And the interest simply is not compelling, and I think that even the dissent in Roe recognized that the interest is not compelling that early in the pregnancy. I understand the state to articulate its interest in preserving all preborn life that may become compelling at some point in the pregnancy, but it's not compelling early in the pregnancy. It's simply not a right that the law is willing, or an interest that the law is willing to protect in derogation of a woman's right that early in the pregnancy.
And my struggle is, what is it about, what do we have in the record that indicates the interest at the beginning of the pregnancy is any different than the interest at 15 weeks, 20 weeks?
So I think one thing we have in the record, and it's certainly established in decisional law about abortion, is that there may be a state interest at the point of viability where the fetus could survive on its own, but there's no interest before that date when the fetus is entirely dependent on the woman. The woman has the ability to decide at that point in time whether she is going to submit to the dependency of the fetus. And the state doesn't have the ability, no matter how compelling the generalized interest in preserving fetal life, to come in and derogate the woman's right to choose at that point in time. Nor is it narrowly tailored. I mean, the right the interest in preserving preborn life, even if it is fundamental, and even if it is compelling, still has to be narrowly tailored, right? It has to be a rare invocation of a right that can diminish the force of an otherwise protected fundamental right. And an outright ban on all abortions, starting at conception, simply isn't narrowly tailored. It may be that the state has an interest in eliminating entirely all abortions, but that interest still has to be narrowly tailored or advanced in a narrowly tailored way by the state legislation that's at issue. And a total ban doesn't do that. It simply runs roughshod over a right and says that the state's interest in preserving preborn life simply eliminates the woman's right to any kind of decisional autonomy. There has to be an accommodation between the woman's protected interest and the state's asserted compelling interest. And I think that, I shouldn't have used the word balancing, but I do think that strict scrutiny attempts to accommodate the force of these two rights that are respected by the Constitution. And so maybe the compelling interest inquiry isn't precisely the place to go, but narrow tailoring is. I mean, there's nothing narrowly tailored about a ban that eliminates the right to an abortion entirely.
We've talked about the woman's right and the state's interests. Is there any right of the unborn fetus?
I don't think the Constitution protects the right to the unborn fetus. I think the fetus's interests are represented by the state's interest in preserving fetal life, which is why the state comes in essentially as a surrogate to advance that interest. So the interests of the fetus aren't not at issue here, and they're certainly represented by the legislature, which is acting on their behalf. And so, again, as I responded to Justice On's set of questions, I think that those interests are accommodated through the strict scrutiny framework. They respect the interest of the state in preserving fetal life. They certainly respect whatever interest the law is prepared to recognize for an unborn child, but they have to weigh that against the fundamental interest of a woman who is forced to bear the pregnancy against her will for 40 weeks. So the question then becomes, how does the law accommodate those competing interests? And it's certainly not by applying rational basis and deferring entirely to the judgment of the legislature, which seems prepared to read the woman's protected right out of the Constitution entirely in the service of the right of the unborn child.
So are you suggesting that viability is the line between where the state's interest arises and ends?
I don't think it's where the state's interest ends. I think it's possibly where the state's interest begins to be compelling and possibly narrowly tailored under the strict scrutiny framework for purposes of evaluating a ban on abortion. But it's certainly a useful starting place for that analysis. But again, I don't think that question is before the court today. I understand that the court is concerned about how establishing abortion as a fundamental right under the Idaho Constitution is going to result in the same 50 years of litigation the federal courts have dealt with under the Roe and Casey framework. But for today's purposes, I think what matters is whether the total ban and the 6-week ban are drafted in a way to derogate entirely a woman's fundamental right to an abortion. And so I would leave to a later date. I don't know what the legislature is going to do on the understanding that this court respects the woman's fundamental right to make the decision whether to terminate a pregnancy. I don't know what the legislature is going to propose.
But you're asking us to determine the fundamental right and not determine its parameters. Can we do that?
Absolutely.
Or should we do that?
So I think the court can, and I think it should. I think, certainly in areas as sensitive as this one, the court, if there's no need to decide, I think the court should not decide it. I think there's a need not to decide it. What is before the court today is a total ban and a 6-week ban, and those are patently unconstitutional under any analysis once this court recognizes that a woman's right to decide whether to terminate a pregnancy is respected by the Constitution. And so I would leave to a later date precisely how to define the outer bounds of that right, or how to apply strict scrutiny to that right in the service of, or in connection with other regulations that the state might choose to adopt. But the catastrophic complete bans that the legislature has chosen to enact simply can't be the state of the law in Idaho.
Let me be clear about what you're arguing then. Are you suggesting that if we agree with you in this case and rule in your favor, that means abortions could take place at this moment, at the moment we make that decision, any time from conception to birth?
So my understanding is that there's a 20-week ban on the books in Idaho. I don't know the status of that ban. I think that there was some federal court litigation about it. But there is other legislation in the state that provides parameters around when an abortion can be when the right to an abortion can be exercised. And so all this court would be doing is striking down a total ban and the 6-week ban. I don't know what, I do believe that there are regulations around the exercise of that right outside of the total ban and the 6-week ban.
What about the private right of action? You've mentioned the 6-week ban and the
Sure. So I'm happy to turn to that. I think in Justice Brody's opinion on the stay, one of the facts that the court identified as dispositive is that the total ban was in effect, and so the 6-week ban was completely unenforceable. And so that resolved the issue presented by Mead versus Arnell about the separation of powers. As the state has acknowledged in its papers, there is an injunction against the total ban with respect to particular types of abortions, which means that in at least some respect, the total ban is not enforceable, which means that the 6-week ban is enforceable in certain respects. And I think we point to that in our vagueness challenge. So at least from some perspective, there is a universe in which the 6-week ban is the operative ban, the state is prohibited from enforcing it, under SB 1309, and the Mead versus Arnell issue has now been resurrected. And I think that there is a lack of clarity as to precisely what the parameters of the operation of the total ban and the...
You keep using the word unenforceable. Is it really that it's superseded?
So the language of the statute is if the total ban becomes enforceable, then the 6-week ban is superseded. Right? That's the language of, I think, section 8851. So with respect to a particular body of abortions, the total ban is not enforceable, and whether you want to call that enjoined, rendered unenforceable by the supremacy clause, whatever, they're not enforceable. So at least with respect to those abortions being performed in EMTALA compliant or participating facilities, SB 1309 sort of is an enforcement mechanism available to private civil plaintiffs, and the Mead versus Arnell issue was not resolved because there, the law enforcement authorities of this state are stripped of their authority to enforce it, and only private civil plaintiffs can do so. And so I think that raises the separation of powers concern that we had talked about at the stay argument. There are other problems with SB 1309 that the court has not addressed or didn't address in the stay opinion that I'm certainly happy to go through. It's a special law, and it violates the Constitution's equal protection guarantee. And I realize we've sort of hurdled over the 6-week ban, and I'm happy to return to that substantively, and I'm only addressing the civil enforcement provisions. But 1309 is a special law, and it violates the Constitution's equal protection guarantee. It subjects abortion providers, unique among healthcare providers, to private civil claims brought by a broad universe of potential plaintiffs with statutory penalties and a 4-year statute of limitations. And these departures from the closest analogous causes of action for wrongful death are completely unjustified by anything other than the legislature's disapproval of abortion. The legislature's only proffered explanation for the construct SB 1309 operates under is to shield it from federal court review, but none of those things is necessary to shield that legislation from federal court review. Instead, it violates the prohibition on special laws because it's arbitrary and irrational. There's no explanation for why any of those features of SB 1309 would be necessary to advance the state's interest. SB 1309 is also unconstitutionally vague because it provides unbounded penalties that both fail to give providers notice of their potential exposure and are unconstitutionally excessive.
Counsel, just help me understand, what makes a law a special law? I mean, we have all kinds of laws on our books that apply just to water users, that apply just to hunters.
Sure.
What makes the fact that we've picked abortion as a medical activity to be something that's subject to these laws a special law? How is it any different than our other laws that do the same type of thing? So
the standard that the court applies is something similar to arbitrary, capricious, and irrational. And so the question is whether there's any justification for, at least in this context, a departure from the norm. Abortion, the challenge to the abortion statute, or the challenge to the provision of an abortion under SB 1309 is akin to a wrongful death tort. And so you look at the wrongful death tort and you look at the very material ways that the legislature has chosen to enact in this particular context, and you ask whether there's anything non-arbitrary or rational about the distinctions that the state has drawn between the traditional wrongful death statute and the civil action enforcement mechanism of SB 1309, and there is none. The state has given no justification for why it's extended the statute of limitations from 2 years to 4, why it's broadened the universe of people who can bring that sort of claim, or why it has allowed for statutory damages at a floor of $20,000. The only justification for SB 1309 that the state has offered is that it was constructed in the way that it was to avoid federal court enforcement, or to avoid a federal court pre-enforcement challenge, and to allow this court to be the ultimate adjudicator of the constitutional questions that it presents. None of that has to do with any of the special features of the law. And I think when legislation tinkers with the rules of procedure that are generally applicable in the state in order to disfavor a particular class of defendants, or to favor a particular class of plaintiffs, or to favor a particular claim with no rational basis, this court has been particularly wary of that. And I think the one case we point to in our brief that evidences that best is Big Butte, where the court struck down as a special law a particular service of process provision that related to a particular set of favored claims or favored claims from the vantage point of the plaintiff. And the court said, no, you don't get to monkey with the rules of procedure that are otherwise applicable in this state. It is, a special law in violation of the prohibition on special laws in the Constitution. I'm happy to turn with my time left to talk about vagueness or equal protection with respect to either the 6-week ban or the total ban. I'm happy to start with vagueness and the total ban. But left rank supplies the standard. I know there's been a lot of back and forth about the standard here, but left rank is the operative standard. This is a criminal statute. And what left rank says is that if the party to a criminal statute is required to, quote, guess at the meaning and may, quote, differ as to its application, the statute is unconstitutionally vague. And there are multiple provisions of the total ban which require Idaho providers to guess at the meaning of the statute. The state submitted supplemental authority the other day, and one of the cases they point to is a Seventh Circuit decision from 2021, where there are criminal provisions associated with the failure to report I think, a list of conditions that arise as a result of an abortion. And the Seventh Circuit reaches the conclusion that that language is vague under the relevant constitutional provisions because no one can say whether these different conditions arise as a result of an abortion. It's too broad. Where the court refuses to strike it down is because it says this is a pre-enforcement facial challenge to a state law, and for reasons having to do with federalism, this federal court is not going to intervene and entertain this facial pre-enforcement challenge when I think it was Indiana courts have not yet interpreted it. The relevant Indiana agency hasn't implemented any sort of guidance as to what that language means. None of that is relevant here. This is the Idaho Supreme Court sitting in judgment of an Idaho statute, and so none of those federalism concerns is at play. And I think the first part of the Seventh Circuit's analysis in that case is quite useful here because it points up a number of the ambiguities, the unconstitutional ambiguities in the total abortion ban. First, and I think critically, the two provisions that render the total abortion ban vague are affirmative defenses. They are not exceptions to the statute. An affirmative defense is an excuse. The conduct is still criminalized. A person who performs any abortion has committed a crime. The question then becomes whether they can convince a jury by a preponderance of the evidence that they're entitled to an affirmative defense. The entire structure of this statute raises due process concerns that are only worsened by the fatal ambiguity in the statute. Second, the affirmative defenses are only available if the provider can demonstrate to the satisfaction of a jury after being prosecuted, held into court, and put to a jury trial, they can demonstrate that the abortion was, quote, necessary to prevent the death of the pregnant woman. There's no guidance as to the imminence or temporality of that necessity. And the indeterminacy about how much risk qualifies as necessary is vague. A provider cannot make that determination. It is medically impossible. And in order to avail oneself of the affirmative defense, to be put on the horns of that dilemma about whether to perform an abortion or whether to decide whether you're going to be able to satisfy a jury that the abortion you're providing is necessary to prevent the death of the pregnant woman, I think, again, renders the statute unconstitutionally vague. And I think Judge Windmill's decision in the federal court EMTALA challenge recognizes all of the ambiguities in the statute.
How are the affirmative defenses provided in this case any different than the other standard affirmative defenses that come up in criminal cases, like self-defense, alibi, innocence, some kind of an emergency situation that justified? Those all have to be brought up by the defendant himself and it would act, I think, very similar to the affirmative defenses in this case. So what makes this different?
Sure. So I think there's two issues. The first one is that they're vague for all of the reasons that we mentioned in our brief. So unlike the ones that you've just described, there's just a fundamental problem with being able to deploy the affirmative defense and rely on the affirmative defense. Second, I think as the 6-week ban makes clear, the ordinary structure for these statutes is to make abortions that are necessary to preserve or protect the life or health of the mother as exceptions to the statute rather than affirmative defenses. That ensures, at least to some extent, at least when the exceptions are not vaguely written, that a doctor can assure himself that he is not providing an abortion in violation of the statute when he or she performs an abortion necessary to protect the life of the mother. Making it an affirmative defense means that you have criminalized the provision of medical care that the state nonetheless recognizes at some level may be necessary to protect the life of the patient. And so putting the onus on the doctor in those circumstances, I think, is quite different from a circumstance where everyone agrees that murder or robbery is something that can otherwise be criminally prohibited, and that there may be extenuating circumstances that can justify the availability of an affirmative defense. But I think the construct here, where the legislature seems to have recognized that there are less culpable abortions or abortions that ought to be provided, perhaps to satisfy even rational basis review for the abortion statute, making them affirmative defenses, I think, just complicates matters rather than making it a legitimate way for a doctor to provide care consistent with her medical ethics and the need of the patient. I think the affirmative defenses you've mentioned are certainly well established, but they also rest against underlying criminal prohibitions where no one would question whether the underlying criminal prohibition subject to the affirmative defenses or not satisfies due process. So I think the legislature's overstepped its bounds here by establishing these.
So, for example, you think our self-defense laws in a case of murder are so clear that they don't ever get challenged in court?
I haven't considered those. I'm positive that there's lots of litigation about whether those self-defense laws are sufficiently clear on their face. But the statutes we're talking about here are written in such a way as to provide providers with absolutely no guidance, and more importantly, no assurance that they would prevail in a defense against a criminal prosecution when what they're doing is providing medically necessary care, as seems to be contemplated by the legislature, as what is an exception. I mean, there's no rational explanation for why these are presented as exceptions to the 6-week ban, but affirmative defenses to the total ban. So I talked about necessary to prevent the death of the pregnant woman. The rape and incest affirmative defense requires providers to reach legal conclusions about factual narratives in police reports in a way that, again, I think renders them completely unavailable to medical providers. There's also this nonsensical requirement that applies to both the affirmative defenses, that the abortions have to be performed so as to provide the best opportunity for the unborn child to survive. That provision may make sense when it's applied to the 20-week ban we described earlier, because there may be circumstances where after 20 weeks, an abortion can be performed in such a way as to maximize the chances that the fetus will survive. But as applied to a total ban or a 6-week ban, it makes no sense at all, and it renders the affirmative defense completely unavailable.
Why would that be always nonsensical? If a woman in her 3rd trimester with a potentially viable fetus had to undergo an emergency abortion to save her life, and it was authorized under this, shouldn't every action be taken to preserve that life? And why would that be nonsense?
I certainly agree with that, and that's why I say I think it makes some sense in the context of the 20-week ban, where you're only talking about abortions performed after 20 weeks. But when you're talking about abortions performed from the moment of conception, being outlined by the total abortion ban, it makes no sense. And
that's not a facial challenge. That's an as applied challenge, isn't it?
Well, I think it's a facial challenge to the total abortion ban.
Well, then it's not a proper facial challenge if it can be used appropriately in some instances.
I understand the point. I think the total abortion ban operates to ban abortions between conception and 6 weeks. The 6-week ban then does something else 6 weeks and forward, at least in certain circumstances. I think as applied to abortions at the moment of conception, or even at 6 weeks, or even farther than that, there is no way to perform those abortions consistent with the requirement of the affirmative defense. And so whether you evaluate this as its own sort of facial vagueness, or the fact that as applied to either of the two affirmative defenses, it renders them further unconstitutionally vague, I think the court can sort of puzzle through it either way. But the point is that the legislature, in enacting the
and let me ask you, in Justice Moeller's scenario where we're talking about a 3rd term delivery, would that even fall under the definition of an abortion or a 3rd trimester, if by that trimester you've got a viable delivery, and with medical interventions, that baby could survive? Because as I read the definition of abortion, it's likely to result, or reasonably likely, I can't remember the language, to result in the death of the child. And so if you're just doing a delivery and it's a preterm delivery, that's not necessarily an abortion, is it?
I think that's certainly right. There are certainly factual scenarios where it wouldn't, where an abortion later in the fetal development would not constitute, I shouldn't have used the term abortion, where a procedure later in the term that results in the delivery of a live fetus obviously wouldn't constitute an abortion, which as defined under the statute constitutes something that intentionally is meant to and does procure the death of the fetus. But I think, again, you've got two affirmative defenses which are unclear on their face and provide providers with no guidance as to whether or when they can be invoked, and certainly provide no assurance that they'll be found by a jury to have successfully demonstrated by preponderance of the evidence that they've invoked them. And they're rendered further vague because they both include this procedural requirement that the abortion be conducted in a particular way, which in the vast majority of cases, since the vast majority of abortions are performed in the first trimester before the point of viability, I don't think, to the extent your question, Justice Mueller, was talking about whether there's a core of constitutional conduct, I think we're talking about the vast majority of abortions being provided under circumstances where there is no chance for the fetus to survive the procedure. And so this provision renders it unconstitutional. I see I've gone over my time and I've reserved 10 minutes for rebuttal, so I'm happy to take a breather.
Very well. Thank you. Redondo, I believe you've agreed to split time equally with interveners, so you have 30 minutes.
Thank you, Your Honor. Mr. Chief Justice, may it please the court and counsel. Petitioners come to this court with a policy dispute. They think abortion should be legal without the lives of the preborn children who will be lost because they perceive abortion to offer benefits to women. The state has come down on the other side of the policy ledger. Now that Roe has been reversed, the state has exercised its power to protect the lives of preborn children, except when such a life would come at the expense of the woman or in the cases of rape or incest. This is a battle that is properly waged at the ballot box. It is not this court's place to adjudicate policy disputes. But petitioners would have this court basically amass unchecked power to declare fundamental rights in order to adjudicate this policy dispute. This court's task is far more limited. It is to interpret the provisions of the Idaho Constitution to be consistent with the intent of the drafters. And there is no evidence that the drafters of the Idaho Constitution intended to protect as a fundamental right the ability to have an abortion. With regard to petitioners' vagueness arguments, which I want to touch on briefly in this introduction, this court should reject petitioners' newfound challenges to terms abortion providers in Idaho have long understood. On this facial pre-enforcement challenge, all of the terms and phrases petitioner challenge have a core discernible meaning. And if petitioners' concerns with some marginal interpretations have merit, they will arise as applied challenges that can properly be adjudicated by the courts. In the meantime, this court should heed the presumption of constitutionality that is afforded to legislative enactments and uphold the challenged laws against petitioners' various challenges. The petitions should be denied for 3 reasons that I'll talk about today. First, there's no right to abortion hidden in the Idaho Constitution. Second, petitioners' vagueness arguments are ill-disguised disagreements with the policies underlying the challenged laws, not the inability of an ordinary person to understand the core meaning of those laws. Third, the challenge laws read together are perfectly comprehensible. And fourth, the civil action is not an impermissible special law. But first, I want to draw this court's attention to the shifting sands of petitioners' rationales. As these 3 cases have evolved, petitioners have come up with new reasons for why these laws are problematic, and basically conceded that the first arguments weren't very good. So today, for the first time, petitioners come to this court and say, it's the fact that these are affirmative defenses that render these laws.
Counsel, is that a fair argument, though? I mean, when this was first filed, Dobbs hadn't been decided yet. When this was first filed, there wasn't an abundance of recent circuit court opinions discussing this. I mean, this has been evolving before our eyes as this case is taking place. Shouldn't their arguments be able to reflect some of that changing legal realities?
Well, certainly as to Dobbs, Your Honor, I overplayed my hand there. But the fact that petitioners came to this court today and argued the fact that these are affirmative defenses, that renders the laws unconstitutionally vague. That's a totally new argument that we just heard today. And it really evidences the fact that once petitioners sit down and look at these arguments, they become concerned that they're not powerful enough. So to turn...
Why is that a reflection that they don't think their existing arguments are powerful enough, as opposed to they identified some additional arguments, which there's a difference there. So why do we automatically assume the original arguments aren't worthy?
Well, Your Honor, it's because when counsel come to oral argument, they want to express to this court the most important, most powerful law arguments for their position. And the fact that petitioners chose those particular arguments to make to this court today suggests that they think that they're the most powerful, the most compelling arguments that they want this court to really recognize.
Or they're relying on the arguments they made in their brief and they're expounding on that here.
Well, I would disagree that they're expounding on the arguments made in their brief with regard to this new affirmative defense.
I understand.
But I take your point, Your Honor. But certainly, I do, not only is it a suggestion that petitioners are reconsidering their arguments, but also it's impermissible to raise new arguments on reply, let alone an oral argument. So the court should not consider this new argument that's been raised. With regard to whether there's a right to abortion under the Idaho Constitution, again, petitioners have this shifting stance rationale for why such a right exists. And they've variously called on different constitutional provisions to argue that such a right exists. But whether this court is interpreting ordered liberty or a right, or Article 1, one of the provisions under Article 1, either read together or separately, it's well established under this court's precedence that the court's role is to interpret what the drafters of the Constitution interpreted. And basically what petitioners said to this court today is, don't worry about what the drafters intended. The drafters didn't actually know what they intended or didn't articulate what they intended, and the state of Idaho wasn't articulating what it was actually thinking about abortion. So they completely, in silence, created this right to abortion under the Idaho Constitution. And everybody is supposed to ignore the state's long history of criminal laws that prohibit abortion from 1864 until Roe was decided.
So, Ms. Lorando, Idaho, in drafting its constitution, reversed the order of importance, and the Declaration of Rights became Article 1, Section 1. Article 1 is the Declaration of Rights, and Article 1, Section 1 talks about life, liberty, pursuit of happiness, which doesn't exist in the U.S. Constitution. Similar states with similar constitutions, Mississippi and Kansas for two, have concluded that there is a fundamental right under their constitution because, in part, the recognition of the Declaration of Rights being so important and so central to what ordered liberty is all about. Are you familiar with any state that has a constitution similar to ours that has concluded that there isn't a fundamental right to abortion?
Your Honor, I cannot point this court to a case like that, but I would emphasize for this court that the various Supreme Courts that have found a right to abortion under their Constitution have been kind of under this misapprehension caused by Roe, that there is some sort of liberty interest in having an abortion. But as the Supreme Court pointed out in Dobbs, whether we're talking about liberty or ordered liberty, the test is basically the same. And that is whether the right is deeply rooted in the nation's history and tradition, and whether it's essential.
But in Evans, didn't we specifically say we weren't adopting the deeply rooted language?
Well, Your Honor, Evans interpreted a specific constitutional provision. Evans did not find a right or absence of a right under the ordered liberty test that was mentioned in that case. So Evans really cannot be viewed as guidance as to what one looks at when analyzing what ordered liberty is.
And so I guess my concern in this case is I don't know how, under the right to liberty, you say there is not a right to make decisions about your own body. And as I understand petitioner's argument, they're saying this, whether you call it a right to privacy, a right to be left alone, a right to abortion, that's implicit, in part, in the right of liberty that I get to make decisions about my body. So help me understand how my right to make decisions about my body is not included and implicit in the right of liberty, happiness in Article 1, Section 1.
Your Honor, the difference is that abortion takes a potential human life.
And
extracting a tooth.
And so that may give the state a compelling interest to pass a law, but that doesn't change that my right to liberty includes my right to make decisions about my body. That's my struggle, is I worry we're collapsing the analysis here and we're ignoring the fundamental right and instead saying the history of criminalizing abortion indicates there is no fundamental right, when in reality, the history of criminalizing abortion is attempting to regulate the right.
So I disagree, Your Honor, because you have to look at and acknowledge the history of criminal prohibition of abortion at the time the Constitution was adopted, because the court's task is ultimately to discern what is the intent of the framers. And if this court were to find a fundamental right to abortion and then say, well, we can fix this by saying it's a compelling state interest to preserve a compelling life, that is really ignoring what the drafters of the Idaho Constitution understood that they were doing. Because abortion was so consistently criminalized. And as Justice Mueller pointed out, even this court in 1901 described abortion as contrary to moral law and the laws of decency and criminal law, and that it had grave consequences to society. And so with that backdrop, which petitioners, I think, really erroneously tried to erode with some irrelevant newspaper snippets, there can be no thought that the drafters of the Constitution thought that abortion was a fundamental right that they were protecting.
So are you saying the right to liberty does not include the right to make decisions about my own body?
I'm not saying that, Your Honor. I'm saying that the right to liberty stops when that decision about making your own choices about your own body takes a potential human life.
Well, it seems if you're going to give an inalienable right of liberty, you give everything that comes along with it. And then, if you want to make arguments about a compelling state interest that allows you to pass laws about it, you can do that. But my struggle is with how the founders would grant an inalienable right of liberty that I think clearly includes the right to make decisions about the body, and then we start parsing it out and saying you only get to make these decisions about your body. These decisions about your body aren't protected.
Well, the only part of liberty that I'm pulling out is the right to make a decision that terminates a potential human life. And that is where, the court in Dobbs, I think, really had it right when the court said ordered liberty does not encompass an activity that takes a potential human life. As petitioners, I think, pointed out really clearly by saying, ultimately, their argument is that there's some sort of right to do whatever one wants. That if one wants to engage in drug use, because that's just something that they do to their own body, that's a constitutionally protected liberty.
Well, I don't think that's fair in this case. They haven't made that argument in this case.
But they have said that the right to liberty includes the right to be let alone.
Right.
And that...
And they've made that argument in the context of abortion. I don't know that it's fair to start, expanding that and arguing kind of all the crazy places it could go, because, it probably could go crazy places. But
that's the exact point that Justice Alito made in Dobbs, which was that ordered liberty has to have boundaries, because if liberty just means the right to do whatever one wants, the right to make any decisions one wants about one's body, it necessarily goes crazy places. And that's why the court has to understand, in determining what a liberty right is, that it has to be an ordered liberty. It has to be something that doesn't take a potential human life.
So it seems like you are arguing that the unborn life takes priority over the woman who has become pregnant.
I disagree with that, Your Honor. The state is concerned with protecting life. And so when
the mothers, apparently.
I disagree with that, Your Honor. And I think this goes to this kind of misconception that has been articulated about 18622, that it bans all abortions. It does not. It allows for abortions in the case where the abortion is necessary to protect the life of the mother. So where there are two lives at stake, then the woman's life is protected. It's simply...
What about her health?
The woman's health is
not mentioned in the statute.
Is not mentioned in the statute. And I wowould not read 18622's affirmative defense as saying that an abortion is allowed when necessary to protect the woman's health. It is only when the abortion is necessary to protect the woman's life.
So we don't care about the woman's health?
I disagree with that, Your Honor.
Show me how we care about that when we haven't mentioned it in the statute and you said it wouldn't be applicable.
concern at the point of the woman's health is that an abortion would take the fetus's life. And so when we have lives at stake, the legislature has drilled down to the point of protecting life. And so the fetus's life cannot be terminated at the expense of the woman's health, but it can be terminated to save the woman's life.
So you're saying we don't care about the woman's health?
I disagree with that. I disagree with that articulation, Your Honor. We certainly do care.
I didn't understand your distinction that you were drawing.
Well, we care about the woman's health, but we care about life, the life of the fetus as well.
So the life of the fetus overcomes the health of the mother?
Yes, Your Honor, because the legislature is concerned with and the drafters of the Constitution, because that was the law that was in effect when they were drafting, were concerned with drilling down and protecting life. And so when life came at the expense of life, then the woman's life could be protected. But when health came at the expense of life, the fetus's life is the thing that is protected. I also want to touch on petitioner's argument that there's some sort of right to privacy in the Idaho Constitution. And in reading their brief, most of the cases that petitioners cite to are interpreting state laws where there is an explicit right to privacy in that Constitution. And so...
What about Murphy?
Murphy is utterly inapplicable, Your Honor. Murphy was about...
Didn't we say there was a right to privacy in Murphy? Isn't that the word we used?
But Murphy was about...
Some of us are old enough to remember that decision because we had long hair in high school, and that's what the case is all about.
Well, the court may have used the word privacy, but it was the wrong word, to be quite honest, for what the court was actually
So we just
protecting.
ignore what our predecessors said.
Certainly not, Your Honor. I'm just saying to read the case in toto and not pick out a certain word. Because Murphy was about the right to wear one's hair at the length that one wants. It was really the public expression of one's personal taste, which is really the opposite of the right to do in secret whatever one wants with one's body. With regard to Justice Muller's point about this argument about procreation, I completely agree that procreation is the opposite of abortion. And so any sort of dialogue about whether there's a right to procreation under the Idaho Constitution is really irrelevant to the question of whether there is a right to terminate a pregnancy under the Idaho Constitution. And then to the Section 21 argument that petitioners have raised. I disagree that the court interpreted Section 21 to say that Idaho provides more protection than the federal Constitution, full stop. When the court has exceeded the scope of privacy protections provided by the federal Constitution, it has examined Idaho-specific circumstances in reaching that determination. And so, for example, it looks about the concept of curtilage and thinks, well, in Idaho, curtilage is kind of different than it is in other states. And then I'd like to touch on the court's dialogue with my friend about what standard applies. And I think that the fact that the petitioners are really not able to articulate a standard that they would have this court apply if this court were to declare abortion a fundamental right is really evidence that the court should not declare a fundamental right to abortion. Certainly all the cases that I have read where a Supreme Court declares a constitutional right to abortion, the court then talks about the standard that will be applied to that right. And the fact that petitioners continue to discuss some sort of balancing of the fetus rights versus the mother's rights really indicates why this court should not find a fundamental right to abortion under the Idaho Constitution. To turn to petitioners' vagueness challenge.
Actually, I'm not sure that is their argument. They seem to disregard the life of the fetus altogether. It seems to just be a conversation about state interests versus the mother's interests, and there's zero conversation about the fetus.
Well, certainly I agree that that's the case in the petitioner's briefing. Today I understood the petitioner's dialogue with the court to discuss some sort of balancing of the fetus's interests versus the mother's interests, at least at a certain point at viability, I would assume.
And I read your brief to suggest that the fetus has a fundamental right. Did I misperceive that?
I think that I don't think that that's a necessary read of our brief. Our brief is that our brief argues that there's no fundamental right to abortion. And so that means that the state's law that prohibits abortion in most circumstances must be reviewed under rational basis review. It doesn't mean that the fetus necessarily has to be found to have a fundamental right in order to uphold the state's laws against this
So I
kind of challenge.
misperceived your brief in that regard, the due process rights of the fetus.
There is a reference, Your Honor, you are correct, to the due process rights of the fetus. I think that is an argument that this court could adopt, but it's certainly not necessary to denying the petitions.
We haven't ever adopted it before.
No, Your Honor, you have not.
Has any court adopted it before?
Not to my knowledge, but I haven't exhaustively examined it.
So before you get to your vagueness discussion, if this court holds that there's a fundamental right at issue here and we get to strict scrutiny analysis, I understand that the state is alleging its compelling state interest is the protection of life. Do Idaho's faith healing laws undercut that argument?
No, Your Honor, and that is because the compelling interest here is the protection of life, and the state achieves that through the necessary and narrowly tailored mechanism of prohibiting a procedure that takes life. So the faith healing laws are different because those procedures that are followed under those laws are not necessarily intended to take life.
Well, counsel, they provide an absolute defense to a parent who allows their child to die of a preventable medical condition because they don't wish to provide them with medical treatment. So if the state has a compelling interest in protecting life, why isn't it asserting that in that scenario where you've got a medical doctor that is saying this is preventable, this child is going to die if they don't receive medical treatment?
And I think there's two answers to that, Your Honor. One is that this law is exactly targeted at preventing the procedure that takes life, but also to Your Honor's question that I think is asking about this compelling state interest, those faith healing laws are impacted by religious rights.
Well, I considered that, and I did some research, and I could not find a state or court decision that held the parent's religious interests override the state's compelling interest in protecting the life and the safety of its children, or overriding the child's interest in life.
Well, Your Honor, I don't think that, again, I don't think that those laws are really applicable here because they're distinguishable from the affirmative act of performing a procedure that takes a life, as opposed to what is kind of the non-performance of a procedure that kind of necessarily ends or would potentially end in the loss of a life.
Well, it'd be involuntary manslaughter, but for the defense.
Right, Your Honor.
So it's a criminal act aside from the protection. And my point in asking about it is if the state inconsistently asserts a compelling state interest, does that necessarily undermine the contention that it's a compelling state interest?
Again, Your Honor, I disagree that there is an inconsistent assertion of a compelling state interest. Those circumstances are distinguishable from the circumstances here where the state is asserting a compelling state interest.
So does the state not have a compelling state interest in saving the lives of those born children who could be saved but for the failure to provide medical treatment?
Well, those laws can pass muster with the state having the compelling state interest in preserving life under the necessary and narrowly tailored prong. But it doesn't have to turn on whether there's a compelling state interest in preserving life.
But my point is you're asserting the compelling state interest of protecting life here, and I'm not sure that the state is consistently applying that interest.
I disagree with that, Your Honor. I think that the fact that these laws respect religious rights and allow the non-performance of procedures is distinctly different from the targeted performance of a procedure that intentionally terminates a pregnancy with a reasonable likelihood that an unborn child will die.
What if on religious reasons parents had a child perform a procedure that was dangerous, like snake handling, for example?
Well, certainly, Your Honor, that law would implicate different constitutional provisions because of the religious freedoms And certainly, I don't think that there's any law that prohibits that.
But I assume the state's not here today to defend the faith healing laws.
No, Your Honor, it is not. And I think, Your Honor, thank you for reminding me that I did want to articulate that these laws do survive strict scrutiny for that very reason, that they are narrowly tailored and necessary because they are so targeted.
Can you respond to petitioner's assertion that they're not ever narrowly tailored if they completely foreclose the exercise of a fundamental right?
So, Your Honor, I disagree that they completely foreclose the exercise of a fundamental right. They provide exceptions, which are couched as affirmative defenses in the case of rape, incest, or when necessary to prevent the death of the mother. And as to whether those are affirmative defenses cause issue with the statute, they simply don't. As Your Honor pointed out, there are a number of affirmative defenses that take people out of the impact of criminal law that are perfectly constitutional permissible. And the fact that that the burden of proof may shift does not provide any sort of vagueness issue. That's an issue for a different day, to the extent that there is an issue.
But to Justice Zahn's point, let's assume that these laws had no such affirmative defenses. In that instance, would there be no ability to prove that it was narrowly tailored? If it was a complete and utter abortion ban with no exceptions, would that be narrowly tailored?
Well, Your Honor, that is certainly not in front of the court today. It would be troublesome, potentially, in that the state is asserting a compelling state interest in preserving life, and if there is no ability to protect the woman's life when the life of the fetus would come, when especially in a pre-viability abortion where both the fetus and the woman will die, that could be constitutionally problematic, but that's certainly not something the court has to decide today.
Let's talk about rape and incest. So, as I understand the statute, it requires the person seeking the abortion to provide a police report to the practitioner to ensure that there is in fact a legitimate claim of incest or rape, or both. My understanding of the criminal justice system is that during ongoing investigations, the police are unwilling to provide police reports. How do you require somebody in that situation to procure a police report when the standard is to not provide police reports during an ongoing investigation?
Well, Your Honor, I hear that concern, and respectfully, that's not a claim that this court needs to consider in ruling on this, because it's not an argument that petitioners have brought to this court. All that the petitioner needs to do to exercise the affirmative defense for rape and incest is to provide a copy of a police report or law enforcement report documenting a rape or an act of rape or incest to the provider. Whether it could potentially be issues with law enforcement providing that report, I think could be addressed by perhaps guidelines being developed that the police need to provide an exception and provide reports for that targeted purpose, perhaps under some sort of protective order or something, for women to obtain the police reports necessary to obtain an abortion.
Does that exception also apply to reports of lewd and lascivious conduct?
Does the exception for rape and incest apply to reports of lewd and lascivious conduct?
Right, if a child is subjected to lewd and lascivious conduct and they become pregnant as a result, can they take advantage of the rape and incest exception?
So the doctor merely has to have a police report that the doctor reasonably believes documents an act of rape or incest. Now, whether, and the person seeking the abortion or their parents have to say, affirmatively, there was an act of rape or incest, here's a police report documenting it. If someone may say that this was an act of rape or incest when it was actually an act of lewd and lascivious conduct, the provider would certainly still be able to take advantage of the affirmative defense if they reasonably relied upon that representation.
How do they know that? What in the statute puts them on notice of that?
It's because they merely need to be told that there was an act of rape or incest and then be given a police report that the person seeking the abortion says documents that act of rape or incest. There's certainly no obligation on providers to have some sort of legal training in evaluating the police report to see what criminal offense would actually be charged based on that report.
Isn't it likely that turning over a police report to a physician who certainly has requirements of confidentiality and the patient has the protections of HIPAA, totally different than turning over a police report to, say, our friends in the media, who would have no such restrictions?
Yes, Your Honor, I think it's completely distinguishable and really would alleviate Justice Stegner's concerns about the ability of a woman to obtain a police report. With regard to the facial vagueness challenge, I just want to touch really quick on a few things. There was an argument that the district court in the Entala challenge engaged in interpretation that really cast doubt on the vagueness or suggested that the necessary to prevent the death of a woman language was vague, but that actually the court did not do that. In interpreting the plain language of the statute, the court said an abortion is only justified under the statute if the treating physician made a good faith determination that the patient would have died if the abortion had not been performed. And that is consistent and clear, has a core meaning to an ordinary person with the plain language of the statute. Where the district court erred was when the court looked at physician declarations to basically read some sort of imminence or temporality confusion into the statute where none exists. Another way of thinking about this language is thinking that the provider may perform the abortion if he determines in good faith that the failure to perform the abortion will directly and proximately result in the death of the mother. And so I ask this court respectfully to deny the 3 petitions.
Thank you. Stewart.
Mr. Chief Justice, members of the court, counsel, Monty Stewart and Danny Bauer appearing on behalf of the legislature. It is the legislature's paramount interest here that this court hold that there is no Idaho constitutional right to an abortion. And that leads me right to Justice Ahn's inquiry. I think what was really going on with your dialogue with the Deputy Attorney General, Your Honor, goes to this issue of the generality of the statement of the right being sought. If that right can be stated sufficiently generally, then it's always going to be granted. And if it can be stated sufficiently narrowly, it's hardly ever going to be granted. And you see this play out in 2 United States Supreme Court decisions that you're familiar with. Glucksberg out of Washington State, assisted suicide. And Lawrence against Texas, prohibition, the criminal prohibition against homosexual acts. In the Lawrence case, the court said to Texas, you're being way too specific, too narrow in how you're articulating the right these criminal defendants are seeking us to have us vindicate. And so they elevated it, not a lot, but some, and it was enough. And those criminal defendants prevailed. In Glucksberg, the people advocating for assisted suicide came in and they had a very general formulation of the right they were seeking, almost as general as, quote, the right to make decisions about one's own body, end quote. And the court said, no, That's not really the right you're here after. And they came down and identified it more accurately, more fairly. No spin, no propaganda, just what are we really talking about here? And what we're really talking about here isn't some vague, amorphous, quote, right to make decisions about your own body. That's not what they're asking for, really. They are asking this court to hold that a woman has a right, unhampered, unhindered by state action, to abort her baby. That's what this is all about. And let's keep focused on that, because that's the right level of statement in my judgment. The state's interest, or excuse me, the legislature's interest, paramount interest, that this court hold there is no Idaho constitutional right to an abortion. Dobbs, of course, held that there was no federal constitutional right to an abortion. I'm going to suggest strongly that Dobbs marks the path this court ought to follow. Not because Dobbs is in any way binding on you, that there's some legal mandate that you follow Dobbs, but because of the excellence of its analysis. And it is true that Dobbs addresses every argument that has been made by the petitioners here, every one of them, including the new one that came up just today about viability. I give you an example on the viability. You can go to Dobbs at page 2271, and it points out the problem with the arbitrary nature of this viability line. Where on earth does the Constitution say there's something about that line that makes any sense? There's all kinds of lines you can draw. And different legislatures do, and different courts do.
Historically, though, in this country, we've had laws that criminalize abortion after quickening. You see a lot of history. Don't we have a history of attempting to define that?
Well, at the common law, of course, they used quickening for a long time. Dobbs talks about that. I agree with the view that they used quickening because of the state of medical knowledge at the time. How do you know that this unborn child is alive, maybe dead, until there is quickening? Interestingly, after medical understanding or medical abilities increased, then the states in this nation uniformly walked away from the quickening standard and went to strict prohibitions. Dobbs has excellent analysis. It answers every one of these questions in my judgment. And I suggest strongly that analysis that you see set forth there applies more forcefully in Idaho than across the nation generally, for two reasons. Number one, the Idaho Constitution has never had a Roe-like decision imposed on it. In other words, there's no stare decisis fight going on here, and that matters because that was the real fight in Dobbs. The dissenters' arguments on the substantive liberty interests were really quite weak and readily refuted. The big fight was all about stare decisis. You don't have that fight. Number two, Idaho's history and tradition, and I'm going to come back to that because it's so important. From territorial days to this very hour, have been much more pro-life, than the nation generally, compared to the nation generally. And Idaho's conception of ordered liberty has always prescribed a heightened moral value to the life of the unborn child. So now we got to jump into the Evans issue, I think, I'm sure. In our brief in the second case, the 622 statute case, the second case, pages 7 and 8, we address Evans. Evans, I think it's a gross overstatement to say that in Evans you jettisoned and threw forever behind you as a tool for constitutional adjudication considerations, thoughtful considerations of history and tradition. Evans itself said that, look, our inquiry must rest on, quote, neutral criteria, end quote, and avoid, quote, the appearance of result-oriented decision-making. So you need to decide what constitutes Idaho's concept of ordered liberty, nobody else's. Well, how do you determine what Idaho's ordered liberty means? You do have to consider the history and the traditions of the state, not just narrowly legally, but even more broadly, socially, morally. If you don't do that, you're going to be afloat without any neutral criteria. And it's just going to come down to personal policy preferences.
So
you don't want that.
Counsel, I want to make sure I understand what you're saying. Are you suggesting we should be considered societal factors, social factors? Is that what you just said?
I'm suggesting that when you consider, you should be considering the history and traditions of this state. And that history encompasses not just its criminal laws at the time of statehood.
But that's exactly what appellants want us to do. They want us to look at. They want us to look at the
advertisements about abortive.
Counsel?
Oh, I'm sorry.
Appellants want us to look at the zeitgeist. They want us to look at the times, and that we're in modern times now, and this is, we have to come into the 21st century. That's the kind of argument that we hear from the appellants, and so I'm a little troubled to understand what you're trying to suggest to us that here today. It's not what I expected to hear you say.
Okay, well, that's because I misspoke. I'm an originalist. I think it's fair to say that we very much heard an argument for, quote, living constitutionalism, which, in my experience, there's no written constitution quite as dead as one that has fallen into the hands of judges who ascribe to living constitutionalism notions. Because, again, there are no neutral criteria. There's no helpful guidelines. The great thing about Dobbs is it didn't just talk the talk, it walked the walk. It worked through all of the history. It worked through this in order to come to an understanding that was principled and had a solid objective foundation. So I hope that clarifies my mistake.
Well, it does. It does. Certainly attorneys are at their best when they're explaining to us what the law is, and so that's what I'm hoping to understand in response to these arguments.
Right. Well, look, as I studied and thought about the issues before you here, I was struck forcefully by just how inherently and unavoidably legislative abortion is. Whether abortion is a question before the legislature or the question before a court that thinks there is a constitutional right to abortion. Once this court, and heaven forbid it does this, but if this court holds that there is a constitutional right to abortion, if this court says anything other than there is no Idaho constitutional right to an abortion, you are going to be pulled into legislating. It's unavoidable. And that means the need to draw all kinds of lines and to resolve sub-issues and sub-sub-issues. You just look at Roe and its progeny, That seems to me to be conclusive evidence of the truth of what I'm saying.
But isn't that true with any fundamental right that the state tries to pass laws about? Reclaim, I think, is an example of that. I mean, in that case, this court found a fundamental right and was necessarily required to try and explain to a certain extent the contours of that right. So isn't that true of any fundamental right? That if the state tries to pass a law about it, we have to draw some distinctions and give some guidance.
Your question presupposes that abortion is a fundamental right.
Right, but your argument is you can't do this because then you'll have to do that. And I'm saying we do that with other fundamental rights.
You have to do it with other fundamental rights because they are fundamental rights, virtually always, because they're express fundamental rights in the Constitution. And you're the stewards of the Constitution. Therefore, that hard task falls upon you. But it is, with respect to other fundamental rights, I don't care whether you're talking free exercise of religion or free speech or freedom from unreasonable searches and seizures. I don't care what you're talking about. None of the legislating a court has to do in those arenas begins to come close to the detailed, unguided legislating that a court has to do once it utters the fatal words, oh, under our Constitution, there's a fundamental right to an abortion. And that is so, even if in saying that you say, well, it's just going to be a small right. And I think the evidence of that is, look at Chief Justice Roberts' new legislating and his concurrence in Dobbs, his sufficient time, I think that's what he called it, reasonable time. He came up with some more legislating, reasonable time legislating. Of course, the Dobbs majority pointed out that that was just as unprincipled and really as unworkable as the various and shifting lines beginning with Roe through Casey and on and on. I thought Planned Parenthood's counsel was playing the Pied Piper really well. He was piping a lovely tune, and I thought, and he's going to walk this court right into the morass of having to legislate if it decides there's a fundamental right to an abortion under the Idaho Constitution, and legislate in ways that, and the motion to strike that you were discussing, I thought, this almost sounds like this is a legislative committee in front of me. Look, legislating about abortion is hard. There is no harder issue to legislate on. It's hardest morally, medically, socially. Take my word for it. My clients have to do that and have had to do that. And
One of the argument, though, of petitioners that we just declare a fundamental right and leave it to your clients to legislate what that fundamental right is and how these fundamental rights are to be dealt with in Idaho. Leave it to them to figure it out after we declare the fundamental right.
Well, it seems to me, Chief Justice Bevan, that what you're suggesting is you're not going to give any guidelines. You're just going to say there's an Idaho constitutional right to an abortion, and it's broad enough to strike down the 622 statute and the Fetal Heartbeat Act. Beyond that, we're not going to tell you its parameters. Okay. So then the legislature comes back with another law, not knowing what the guidance is. I mean, even Roe felt compelled to write legislation, didn't it, number, when it set out its infamous, notoriously bad trimester legislation? I just think if you say there's a fundamental right under the Idaho Constitution to an abortion, to your grief, you will immediately become and thereafter remain legislators on this hardest of all issues. I had in my notes, by the way, Planned Parenthood is giving you no guidance. They help you in fulfilling this legislative role it is urging on you. Well, in response to your questions, they started to, and if I heard right, the response was something to the effect of, well, viability is a great line. Viability is not a great line. There's no principled basis for choosing that line over any other. I mean, you're right. Once you acknowledge that that fetus is a being and is indisputably human, you're dealing with a human being from the beginning to the end. So any line is going to be arbitrary. Guess what? The legislature's constitutional task is to draw those lines, acknowledging they're not perfect. No, there's no. And they're going to be changed. If I know one thing for certain is, the Idaho laws in front of you now on abortion, assuming you uphold them across the board, as you definitely should, they're going to change. Legislatures will come and go. They'll tweak them. They may make major revisions. That's just the very nature of the democratic process. As a free people and a self-governing people wrestle with the really hard moral, social, medical issues inherent in abortion. Thanks for your patience while I figure out where I'm supposed to go next. Oh, I think I can be helpful in this respect. I want to clarify the Fetal Heartbeat Act and its status, the private cause of action. The private cause of action is in full effect. And let me show you why. The superseding language that gives this 622 statute superseding power, that is limited to the criminal law enforcement of the Fetal Heartbeat Act. I direct your attention to the very last portion of Section 8805. And it just says that 622, quote, shall supersede this section. Not the whole chapter, okay? And the section it's talking about is the section that criminalizes. It doesn't supersede private cause of action. And it seemed to me that there was a little bit of confusion about what this court's August 12th decision said. I mean, I don't think the decision is confusing at all. I think something said about it was confusing and wrong. What has changed about the private cause of action is, I think, the August 12th decision made clear is that it is now not the exclusive enforcement mechanism for abortion laws in Idaho. What is it? Well, you now have criminal law enforcement, direct executive department, executive branch enforcement. And so you have the standard dual program that is so common in our jurisprudence, not just Idaho, but across the nation, where you have executive enforcement reinforced by private attorneys generals. And this private cause of action, the despite all the aspersions that have been cast towards it, is a fine, clear, workable, good, straightforward private attorney general's provision.
And what about the fact that it presumes damages without the necessity of proving damages?
I'm glad you asked that question. Statutory damages are a rather common feature in our laws, statutory damages. And as we say in our brief, and we cite some pretty good cases in support, those are often used in cases where there is good grounds for believing that an award of actual damages will be inadequate to accomplish the legislature's purposes. Maybe they're difficult of proof, for example. And that's all we're dealing with here. I do need to say something. Does that answer your question sufficiently?
I understand what you said.
Okay, thank you.
Counsel, if we apply the reasonable basis instead of heightened scrutiny to the statute that you're talking about, what is the reasonable basis for allowing an uncle of a rapist to have a private cause of action against the abortion provider?
Well, I think this court already knows my strong feelings about references to the brother of a rapist. He's still a human being, and his brother's evil we will not ascribe to him, and he has just lost a niece or a nephew. Now that matters to, especially to folks who have nieces and nephews, or who through what are called miscarriages, spontaneous abortion, have lost a niece or a nephew. Same with respect to a grandson or a granddaughter, brother or sister. I mean, there's solid grounds for them to have standing. And the legislature, I mean, that's just very rational. Kinship ties are real in human nature.
What other category of cases in Idaho do we allow special standing to uncles to seek damages? It just seems odd to me that I can understand maybe if it was a little closer, but just an aunt or an uncle of a rapist, what about their status requires Idaho to extend this standing privilege to them when I don't think do that in any other category of cases that I can think of?
Well, I'm glad you asked that question, because I was disturbed as I sat there and heard the comparison between this private cause of action and the Idaho statute on wrongful death. The legislature made some decisions about how broadly wrongful death should extend in terms of who can pursue the remedy.
So do aunts and uncles typically bring wrongful death actions in Idaho?
They don't. The legislature made a decision. It would be this much. We're not going to go beyond to the next degree of kinship. But they looked at this, and they considered the loss involved, and they decided, okay, we are going to expand this in this context, because you're talking about a particular type of wrongful death.
So if
a criminal intentional.
If an uncle's nephew is run over by a drunk driver, he can't sue for wrongful death. But if the uncle's nephew was aborted, he can.
That's right. Yes, the legislature exercised its constitutional right and fulfilled its constitutional responsibility to draw some lines.
You may very well be right about that. But what's the rational basis for treating them differently? That's what my question is. I'm not suggesting whether they can or can't. I just want to know what the rational basis for that divergent treatment is.
Because, well, I'm going to suggest one, and under rational basis review, that's all you need.
Please.
The loss is particularly painful because it is, by definition, the result of an intentional criminal act. Wrongful death goes to a much broader category of deaths.
Which could include intentional death.
It could include it, but it includes many others also. And the fact that it includes many others also seems to me to more than satisfy rational basis review for the distinction. I mean, if an equal protection argument doesn't wash, I think, in that context.
Well,
And
again,
the
I'm
same
not
thing-
asking equal protection. I'm just trying to understand the rational basis for those provisions.
I've articulated one. I think it fully satisfies the standard. And we have another one. They say the 4-year statute of limitations that the legislature chose. That's horrible. It should have been 2 years. Why should it have been 2 years? Well, because you have a 2-year catch-all for torts. Well, true, we do. But we have all kinds of other statute of limitations that apply to a whole bunch of specified causes of action. Each one is different. The legislature chose 4 years in this case. Is that bad? No. It actually falls right about in the middle of the range of statutes that are provided. I need to talk about.
Let me ask you really
Sure.
quick before you move on. And on the civil cause of action, we're getting back to the uncle. If the uncle hadn't had contact with this family member who impregnated whoever through legitimate means or consensual means or criminal means, would the uncle still have standing, say, if he hadn't talked to his brother for 10 years?
Yes, because he lost a niece or a nephew, his niece, not an abstract niece, his niece.
So there's no requirement to show that he ever would have had contact with that child.
Correct. The legislature gives him standing to pursue this cause of action and gives him a right to seek actual damages. What you're talking about probably goes to the measure of actual damages, but that's for resolution in the case.
Well, he's going to get a minimum of $20,000.
That's right. Which has a number of legitimate purposes for being included. It's an incentive. I've got 26 seconds to say that the petitioners have invoked, when it comes to vagueness, void for vagueness, they have not invoked the federal due process clause. They've invoked only the Idaho due process clause. And that means what governs here are Idaho cases on the standard, and the standard is clear on a facial challenge, and these are undoubtedly facial
Thank you, sir.
challenges
Your
across
time
the
is up.
board.
Thank you. Madam Clerk, how much time does the petitioner have remaining? 9 minutes. Sir?
Try to come in under that. I'd like to start with the framework, and I think Justice Zahn has the framework exactly right here. Declaring abortion a fundamental right is the beginning of the analysis. What follows from it, I want to be unmistakably clear about this, is the application of strict scrutiny. And Justice Brody, to go to your point, I mean, strict scrutiny is the standard of review and the framework the court uses when the interests at stake are existential. They are
Hold on
both
just a
ways.
second. Before you go to the framework.
Sure.
I want to make sure the fundamental right that the petitioners are seeking is the right to abortion.
It's the right to decide whether to terminate a pregnancy, correct.
Okay.
And again, I heard counsel on the other side describe it as, forget what the adjectives were unhampered or unburdened by any state regulation. That's not the framework at all. The framework is exactly, as Justice Zahn articulated, declaring something a fundamental right means that it's subject to strict scrutiny, which accommodates all of the weighty existential concerns on the other side. And Justice Brody, I heard you express concern that the interest of the unborn child is absent here, but I think it's precisely to the contrary. The entire point of strict scrutiny is to be able to accommodate the woman's right to decide whether to terminate her pregnancy and the right of the unborn child on the other side as articulated by the state as a compelling interest. What you heard from counsel for the state say is the legislature has given no consideration to the woman's right to decide whether to terminate a pregnancy. All they have accounted for is the possibility that a woman might die as the result of her pregnancy. And in those limited circumstances, and those circumstances only, a woman may have the ability to seek an abortion. If this court declares abortion a fundamental right, all it means is that future bans and regulations are subject to strict scrutiny under a familiar framework that this court and courts across the country have dealt with in a variety of circumstances. It gives due regard and due weight to all of the competing interests, and it doesn't in any respect turn this court into a super legislature. Courts have been addressing these issues for a very long time, and if you look at the experience of state courts dealing with the application of their state constitutional protections for abortion, the record demonstrates that there's nothing like turning the states into super legislatures. The state of Montana declared a protected right to abortion in Armstrong in either 1992 or 1993. I think the only other case that reached the Montana Supreme Court came this year because the legislature overstepped the bounds, recognizing that the Supreme Court had explained, because of protected interest in the Montana Constitution, there is a protected right to an abortion. And so I think I've sort of come back to the framework that Justice Zahn articulated. I heard on the other side a lot of criticism leveled at me for not articulating adequately where to draw the line in future cases. So I've always understood courts are inclined to decide as few constitutional issues as possible when difficult issues are being presented to them. I've asked you, on behalf of my clients, to strike down as unconstitutional a total ban on abortion and a 6-week ban on abortion.
But in reality, and I appreciate your argument about this court not wanting to be a super legislature, but in effect, aren't you asking us to be a super constitutional convention and write things into the Constitution that the founding fathers of Idaho didn't put in there?
I disagree emphatically, Your Honor, and I know that last time we got into an exchange about originalism versus living
It
constitutionalism.
was a cordial exchange.
Yeah, absolutely, absolutely. I remember it fondly, but to the point that was raised on the other side.
As do I.
In 1971, this court found that there is a right to privacy under the under the Idaho Constitution. And it did so with very little hand-wringing. It didn't engage in a debate about originalism or living constitutionalism. In fact, I think this predates by some time the debate in the courts about originalism or living constitutionalism. It looked at the language, as Justice Segner pointed out, it looked at the language and construct of the Idaho Constitution, and it found that the rights that are reserved to the people in Section 21 and the rights explicitly given to the people under Section 1 include the right to privacy and the right to be let alone. And the court's intuition there was that these rights are so fundamental to a free society that enjoys a constitutionally protected right to liberty that it didn't require going into the heads of the legislature at that time. It required looking at the text of the Constitution, looking at the text of Article 1, Section 1, looking at the text of Article 1, Section 21, and granted, applying it to new factual circumstances. I doubt anyone in Idaho in 1875 was walking around with long hair and claiming a constitutional right to wear that hair to school, but the point is the right was there. And the right was there even before the Constitution was framed, and that's exactly the point here. I grant that this is defining the right at a different level of abstraction or generality, but that's what the legislature's work has required of the court today. The right that we are urging the court to recognize here is one that has been in the Idaho Constitution since its founding days, and it's required elaboration over time, but it is no different than everything else this court has done in the 130-year history of the Idaho Constitution in articulating those rights. And again, going back to Murphy in 1971, which I think is a signal decision of this court, where it declared where the Idaho Constitution lay relative to decisions being made under the federal constitution and under disparate state constitutions. And it concluded that Idaho fell on the line of a protective view of privacy and the right to be let alone. And that's precisely what we're asking the court to apply to these circumstances, which I grant are unique before the court. But again, the circumstances where this court has recognized a right to privacy, a right to be let alone, a right to autonomy, self-determination, bodily integrity, there hasn't been a great deal of hand-wringing about originalism or living constitutionalism because it's so obvious that the protections accorded by the Constitution entail this particular right, which is derivative of and necessary to the exercise of all of those other rights protected in the Idaho Constitution. I think I addressed the points made about Dobbs and the analysis there. I think this court has routinely recognized that this Constitution is different in critical ways from the United States Constitution. And so while Dobbs applies a methodology that might be relevant to consideration of some facts, I've explained, I think, and I think we explained in our briefs, why on the decisive terms of the Idaho Constitution, Dobbs is not indicative. Article 1, Section 1 is an affirmative grant of rights. It is not simply a guarantee of procedural due process. There was discussion at the Idaho Constitutional Convention of writing that out of the Constitution because it was duplicative of the Due Process Clause. And not only did the delegates reject that, but they made it Section 1 of the Guarantee of Rights. There's also Article 1, Section 21, which again embraces these rights that are not positively expressed. With respect to vagueness.
But this court, anytime it's interpreted the Idaho Constitution, has always looked at the history of our laws, at the history of our state. And if you look at our history as it relates to abortion, at the time the Constitution was adopted, it was clearly prohibited by law. It, since that time, has been repeatedly reaffirmed again and again and again. It wasn't until Roe was decided that abortion was legal in this state. How can we just ignore that history today?
I'm not asking the court to ignore it. I will emphasize the court has never been asked to test the constitutionality of an abortion-related law. Never. Not in Alcorn, not in any case that's ever been presented to this court. The question is the right to liberty, bodily integrity, self-determination, a right that is contiguous with the right to abortion, and the right to abortion which is necessary to exercise all of those other rights implicit in the concept of ordered liberty.
But that's why when we started the conversation, I asked you, what's the right that we're being asked to declare it? And your answer was abortion. And I think the legislature's right to the extent that, I mean, the case comes down to how are you going to characterize it? I mean, if you get broad enough, I mean, I looked at Planned Parenthood's briefing. Like, for example, the privacy right to make private familial decisions. I can think of a lot of things that fall under familial decisions that I think people would shudder at the idea that it can't be regulated. Female genital mutilation being one of them. People would argue, well, that's a family decision. Domestic violence, that's a family decision. You see, so if you divorce the conversation about fundamental right from our history, from actually looking at what this state has done from the beginning, I think we do run the danger of this court, the five of us today and the five who come after us, just making decisions based on our own personal policy preferences rather than the law.
May I answer? I see that my time is.
You may, sir.
Okay, I'll be quick, even though this is the fundamental question. This court has long recognized, and the framers recognized, that there's a right to liberty, to secure happiness, to secure safety under the Constitution. And this court has over time articulated those rights in different ways. And the scope and generality of those rights has changed over time. I think what we're asking the court to do today is to locate this particular right in a storied tradition of this court protecting the rights of Idahoans. And I recognize that there are other rights that some might claim to this court, and some of the rights that you've described may come to them, but the question is whether the right to decide whether to terminate a pregnancy is so fundamentally connected to all of the rights that you've identified, and whether it is necessary to exercise the other rights protected under the Idaho Constitution, whether any of the issues that you've identified actually go to the fundamental ability of women to participate in the life of this state, or whether they be stripped of their civil, political, and personal identity by the state legislature. That's the question before this court. And so the question, as I framed it to the court, is certainly, it does sort of play in the level of ambiguity, and I've articulated the very precise right that I think is at stake here, but it is a right that this court has identified in the Idaho Constitution and established is present in the Idaho Constitution in other forms, and all we're asking is to reach the logical conclusion here that this particular right and no other right is before this court. I'm not aware of litigation seeking to protect other fundamental rights, but this right, is it a part of all of the other rights that this court has recognized as being part of the Idaho Constitution? And I think the answer is clearly yes.
Thank you.
Thank you, Your Honor.
Thank you to all counsel, those who both participated and were on brief or otherwise in support. This matter is under advisement both as to the merits of all three cases as well as the motion to strike. We will render its decision accordingly. Court will now stand in recess.